and welcome to today's episode. I'm Nikita Dlima, and you are listening to our legal podcast, where we discuss important judgments and their practical legal implications. Today, we are discussing the Gujarat High Court's decision in Dolly Khilankumar Vadalia, nee Dolly Ketan Barai versus Union of India and others. The case deals with a significant issue under citizenship and passport law, where a person is born outside India to Indian parents but has lived in India since infancy. Can Indian citizenship be presumed for issuance of an Indian passport? To discuss this, I am joined by Mr. Rahul Sundaram, a senior legal professional with experience in constitutional law, citizenship related issues, passport disputes, and public law remedies. Welcome, Rahul.
Thank you, Nikita. The judgment is important because it distinguishes between a person's factual connection with India and their legal status as an Indian citizen. The petitioner had lived in India almost her entire life, but the court had to examine whether she satisfied the statutory requirements under the Citizenship Act, particularly Section 4, Citizenship Act of 1955.
Let us begin with a legal foundation. Since the petitioner was born in Mozambique to Indian citizen parents, why did the court examine the case through the lens of citizenship by descent?
This was because the petitioner was not born in India. She was born on 18th of February 2000 in Sai, Mozambique. Therefore, her claim could not simply be treated as citizenship by birth. Since she was born outside India to Indian parents, her case had to be tested under Section 4 of the Citizenship Act 1955, which deals with citizenship by descent. The key requirement was whether her birth had been registered at the Indian consulate or embassy within the prescribed period or later with the approval of the competent authorities, which is normally about a year. The court found that the requirement had not been established. So her birth was not registered with the Indian consulate at Mozambique.
The facts were unusual because she returned to India as an infant due to a severe flood in Mozambique due to an emergency. Did the court consider that circumstance?
Yes. The court noted that Mozambique had suffered a severe flood and an emergency that the petitioner returned to India on March 14, 2000, when she was around 18 or 25 days old, an infant really. An emergency certificate was issued to facilitate her return. The petitioner argued that because of this emergency, her birth could not be registered with the Indian consulate in Mozambique in time. She had also stated that she never acquired Mozambican citizenship, and never had a foreign passport. However, the court held that the statutory requirement of proving Indian citizenship still had to be satisfied. The emergency circumstances did not by themselves establish citizenship by descent.
So, even though she lived in India since infancy, she studied here, and she later married an Indian national as well, those facts were not enough for her to get an Indian passport?
The petitioner had a strong factual connection with India. She lived in Rajkot, completed her education in India, obtained a master's degree from Saurashtra University, and married an Indian citizen on 30th July 2023. Her husband also had a valid Indian passport and was working in Canada, was a permanent resident there. But for issuance of an Indian passport, factual connection is not enough. The applicant must establish Indian citizenship under the Citizenship Act. Residence, education, marriage, and family ties may be relevant facts, but they do not replace statutory proof of citizenship.
The petitioner also relied on her Aadhaar, PAN, voter ID, and driving license. From an evidentiary standpoint, why did those documents not conclude the question of citizenship?
That is the key takeaway from the judgment. Documents like Aadhaar, PAN, voter ID, driving license, and educational records may not prove identity, residence, or administrative recognition. But citizenship is a distinct legal status. A passport is issued only to an Indian citizen. Therefore, where citizenship itself is in doubt, the passport authority can insist on specific proof of citizenship. In such cases, the petitioner's Indian documents were not treated as conclusive proof, because she was admittedly born outside India and had not shown compliance with the requirements of the citizenship under the Citizenship Act by descent, for citizenship by descent.
So, what exactly was the objection taken by the passport authorities?
The passport authorities objected because the petitioner was born in Mozambique. It required documents such as cancellation of the emergency certificate which was used by her to travel to India as an infant, consular registration of birth, or proof of Indian citizenship. Her passport application was closed and she was asked to produce a certificate of registration or naturalization of Indian citizenship. The petitioner then faced another difficulty when she approached the concerned authorities for such a certificate. She was allegedly asked to produce a valid foreign passport. Her position was that she could not produce one because she had never acquired a foreign citizenship.
That creates a very difficult practical situation. So, how did the court deal with this apparent deadlock?
The court did not direct issuance of an Indian passport merely because the petitioner claimed she was not a Mozambican citizen or because she did not have a foreign passport. The court's focus was on positive proof of Indian citizenship. It held that the petitioner had failed to prove that she was an Indian citizen by birth or by descent. However, the court left the statutory remedy open. It stated that the petitioner may make an online or offline application for citizenship before the concerned authorities, and that such application should be decided in accordance with the law.
There was also a birth certificate that was issued by Rajkot Municipal Corporation showing Rajkot as the place of birth. Why did that not assist the petitioner?
The respondent objected to that, the passport authorities objected to that certificate because the admitted fact was that the petitioner was born in Mozambique. The Rajkot municipal authorities or the municipal corporation's birth certificate recorded Rajkot as the place of birth based on the magistrate's order. However, for citizenship by descent, the relevant requirement was not merely domestic birth registration. The relevant issue was whether the birth outside India had been registered at the Indian consulate or whether delayed registration had been approved by the competent authorities. Since this was not shown, the certificate did not cure the defect in proof of citizenship.
The petitioner also invoked Article 21 and she argued that the denial of passport affected her right to life and personal liberty. How did the court approach this constitutional argument?
The right to travel abroad is connected with personal liberty under Article 21. However, an Indian passport can be issued only to an Indian citizen, and that's what the court relied on. So before claiming passport rights, the person must establish Indian citizenship. Article 21 cannot be used to bypass statutory conditions under the Citizenship Act. In this case, the court effectively held that the petitioner had to first establish citizenship before seeking a direction for issuance of an Indian passport.
Would it be correct to say that the writ petition failed not because the petitioner lacked a connection with India, but because she couldn't establish the legal status required for the issuance of a passport?
Yes, that's the correct reading. The court did not ignore her connections with India. It noted that she was born to Indian parents, returned to India as an infant, lived here, studied here, and married an Indian citizen. The citizenship, but citizenship is a legal status. The court found that she had not proved citizenship by birth or by descent under Section 3 and 4 of the Citizenship Act 1955. As a result, the court dismissed the petition and refused to direct issuance of an Indian passport.
What was the final operative outcome of this case?
The Gujarat High Court dismissed the petition. However, it kept the statutory route open. The court stated that the petitioner may apply for a citizenship before the concerned authorities, either online or offline, and that the authorities should decide the application in accordance with law. So the court did not say that she can never acquire Indian citizenship. It only held that she had not established existing Indian citizenship for passport purposes.
From a practical legal standpoint, what should a person in a similar situation as this do after this judgment?
If a person was born outside India to Indian parents, but the birth was not registered at the Indian consulate, the first step should be to address citizenship status before the competent authorities under the Citizenship Act. A direct writ seeking passport issuance may not succeed unless citizenship is already established. The proper route would depend on the facts, but the person may need to apply for citizenship through the available statutory mechanism rather than relying only on residence, identity documents, or family connections in India.
What are the broader takeaways for Indian families that are living abroad?
The most important takeaway is that consular registration of birth is critical where a child is born outside India to Indian parents. Parents should not assume that Indian citizenship will automatically be recognized later only because both parents are Indian citizens. Identity documents such as Aadhaar, PAN, voter card, driving license, or school records may not be enough to prove citizenship. If documentation is not completed at the right time, serious issues may arise later during passport application, immigration processes, higher education, employment, or family reunification.
What is the broader legal significance of this judgment?
The judgment reinforces that citizenship is governed by statute and it cannot be presumed only from residence, education, marriage, family ties, or identity document. It also confirms that passport authorities can insist on proof of citizenship where an applicant was born outside India and the citizenship is not clearly established. At the same time, the court preserved the petitioner's remedy by allowing her to apply for citizenship before the concerned authorities under the other provisions.
So the central message is that in citizenship matters, documentation is not a mere formality but the very basis and foundation of legal status.
Exactly, the persons born outside India, compliance with the Citizenship Act is critical. If the procedure was missed at the time of birth, the person may still have remedies, but those remedies must be pursued through the proper statutory process.
Thank you, Rahul, for explaining this judgment so clearly. This case shows how courts approach citizenship disputes where sympathetic facts meet statutory requirements. The petitioner had a strong factual connection with India, but the court held that citizenship must be proved in accordance with law before an Indian passport can be issued. Thank you for listening. Until next time, stay informed and stay legally aware.